Growth is not.
Please proceed.
Yes, sir. Growth is not merely by chance. It is the result of forces working together. A warm good morning to everyone. I, Vinit Agrawal, the moderator of the session, presenting on behalf of Department of Law, Prestige Institute of Management and Research in Indore, would like to welcome our esteemed guest, Ms. Utkarsha Nikam ma'am, respected faculties, and all dear students. Today, as panelists, we have Assistant Professor Mr. Nakul Singh Chauhan sir and Assistant Professor Ms. Novrati Dongre ma'am. Student coordinators Ms. Priyanshi Jain, Mr. Nishan Jain, Mr. Kshitij Rajpurohit, and the members of the EML committee, Ms. Kashish, Ms. Garima, Ms. Kiran, Mr. Yash, and Mr. Manjeet. It's my great honor to welcome our guest, Ms. Utkarsha Nikam ma'am. Ma'am is currently pursuing LLM in Commercial and Corporate Law at Queen Mary University of London. Ma'am had completed her graduation from the Government Law College, Mumbai. She had interned under various reputed legal firms and has presented papers in many international and national conferences, and has also published papers in reputed and scholarly journals. One of them is on the topic International Humanitarian Law at the Just Dicey Legal Summit 2018. Previously, she worked as an associate with the real estate team of Kangana and Company. She regularly advises clients in relation to real estate transactions and property disputes. She has developed a deep domain in relation to transactional documentation and title due diligences. Realizing the dearth of content relating to estate laws and the irrational fear in minds of young lawyers and law students towards the real estate practice, ma'am co-founded the Indian Real Estate blog, IRB, to demystify real estate law for such young lawyers and law students. She mentors several student-run organizations, blogs, and research platforms across the country in her capacity as an advisory board member and senior editor in the Advocates League. Ma'am truly believes in giving back to the students in every little way possible and has been instrumental in conducting various webinars to share her deep knowledge regarding real estate laws and also providing guidance regarding the same to budding lawyers and law students. Therefore, today ma'am is with us to share her knowledge on the topic Basics of Due Diligence in Mergers and Acquisition Operations. Mere words are not enough to express the glory of Ms. Utkarsha Nikam ma'am. If any of you want to ask any question during the session, you can write it in the Q&A box. Now, I request ma'am to kindly take over the session. Thank you.
Ma'am, you're on mute.
Thank you. Sorry. Thank you so much for the introduction, and thank you so much for having me here. I shall be sharing the screen. So today the topic for the session is basics of due diligence in M&A operations. As you know, businesses may grow over time as the utility of its product and services is recognized. It may also grow through an inorganic process symbolized by an incestuous expansion in workforce, customers, infrastructure, resources, and thereby overall increase in the revenues and the profits of the entity. Now, having said that, the next question that comes to us is, what is an M&A? Mergers and acquisitions are manifestations of an economic growth and process. While mergers can be defined to mean unification of two players into a single entity, acquisitions are situations where one player buys out the other player and combine the bought activity with itself. It may be in a different forms, for example, purchase, where one business buys another, or a management buyout, where the management buys the businesses from its owners. It may also be undertaken to access the market through an established brand to get a market share and to eliminate competition and to reduce the tax liabilities or to acquire competence to set off accumulated tax liabilities as well as the losses of one entity against the profits of other entity. Having said that, I know the simple question that we will come across is, are the mergers and acquisition the same term or are they the different term? Now, usually mergers and acquisition terms are used interchangeably, but are the two of the most misunderstood words in the business world. Both terms often refer to the joining of two companies, but there are key differences involved when they are used. A merger occurs when two separate entities combine forces to create a new joint organization. Meanwhile, an acquisition refers to the takeover of one entity by another. Mergers and acquisitions may be completed to expand a company's reach or gain market share in an attempt to create the shareholder value. Now, let us understand the basic difference between the mergers and acquisition through this slide. As said, merger refers to consolidation of two or more companies to form all new entity with a new name, whereas acquisition, it is the purchase of an entity by another entity. This can also be done by either acquiring ownership of over 51% of its share capital or by taking assets over the assets of the company. Now, is this 51 share very prominent? No. It depends upon company to company, and it also depends on the organization and what is the structure of the transaction. Now, there are different types of mergers which I will not be dealing in, but just to let you know, there are horizontal merger, there are vertical, reverse, etc. And where there are different types of acquisition which are hostile, friendly, or buyout. Having understood the basic difference, we now come to the letters of intent. Now, you must be wondering why letters of intent is an important topic in an M&A due diligence. Now, after you accept an offer or letter of intent, that is thoroughly known as LOI on your business, the buyer will then begin the due diligence. Now, as you all understand the basic criteria, due diligence is the process of gathering and analyzing the information which is provided by the buyer and also the seller to help the parties determine whether or not to proceed with the business transaction. Before we understand and delve into the term due diligence in deep, we would briefly glance over the concept of LOI. Now, a letter of intent is a document declaring the preliminary commitment of one party to do the business with another. To put it in simple terms, it basically records the understanding which is agreed by and between the parties during the initial phase of the transaction. It is not always binding, but there are two clauses which can have legal effect on the piece of letter of intent. Those are exclusivity and confidentiality. Now, basically, there are general kind of provisions or terms in the letter of intent where the definitions are given. Sometimes the payment that is to be made is agreed, which is almost entirely non-binding. Why? Because it just records the understanding which is agreed by between the buyer and the seller at that point of time. Now, they are just the terms which are just the intent, that is the intention of the parties. They are just what the parties intend to agree in the future. Hence, the term letter of intent is come into person. Now, when we talk about the two provisions, exclusivity and confidentiality are the usually binding and usually the only two binding terms in a letter of intent. Now, when we talk about exclusivity, what is that? It says that the seller will not talk to other parties and will not continue to shop their deal for some period of time. For example, if A is intending to enter into a contract with B, they both will have this clause written down and signed by both the parties to make sure that neither the seller nor the buyer is going outside between those two transactions to seek with other parties and have any negotiations with them. They usually have a lock-in period or a lockout period, which binds both the parties that if in case the transaction does not finalize within, for example, say 90 days or a year, it really depends upon what the parties to agree to. But if it doesn't finalize, then the parties are free to go and negotiate with the other buyers or the sellers. It basically says that the seller will not talk to other parties and will definitely not continue to shop their deal for some period of time. Now, to shop their deal basically means to entertain them or to even start the negotiations or even have the intention to enter into a transaction. Usually 60 days or 90 days, as I have said, but it really depends upon what the parties agree to. Sometimes there are conditions precedent. For example, if A wants to buy a property from B, what happens is B's property is in the condition that it can be sold, but there are some condition precedents which A lays down that until and unless you fulfill that, I will not be considering the offer to buy the property. So therefore, B is binded by the condition precedents. He or they will fulfill the conditions. For example, usually these conditions are compliance related. If there are some certificates which are pending, or if there is penalty sum which has to be paid and which the B has not paid it, then A will point that out. And after complying to the compliances which are within the domain of the B to comply, then A is going to buy for the same. So it really depends from the date of the signing of the letter of intent until the period which is exclusively agreed between the party. It can be a little bit longer depending on the situation. Now, confidentiality is really usually the buyer's agreement. Although the door swings both ways, I mean to say is the seller is also giving out some confidential information during the negotiations, and even the buyer is giving some confidential information which will not be published in the public domain. So it is very important and essential for the buyer and the seller to protect the confidential information, which cannot be usually found in the public domain. But usually it's the seller's concern that the buyer won't use the information which is disclosed to them, to the seller during the due diligence period, other than deciding whether or not to deal with the information. Now, basically, it just means that both the parties, whatever information is shared during the due diligence process, have to make sure that it is not shared with any other third party. And therefore, these two clauses play an instrumental role in a letter of intent. Now, having understood, once a letter of intent is signed, both the parties agree that they won't go outside the domain of these two parties to deal with the transaction, and also agree that this confidential information, which will be shared during the due diligence process, will not be leaked outside both the parties. They now come to due diligence. What is due diligence? Now, in a little complex term, due diligence is a process of verification, investigation, or audit of a potential deal or investment opportunities to confirm all the relevant fact and financial information which is disclosed during, before, or after the due diligence process, and anything else that needs verification, and anything that is brought up during an M&A deal or investment process. Now, when is the due diligence completed? Due diligence is completed before the deal closes to provide the buyer with an assurance of what they are getting. Now, to put it in a very layman and simple terms, it means that investigation in the affairs of a company. Now, you all must have heard the principle of caveat emptor, that is the let the buyer beware. For example, the buyer has to be cautious of what he is buying. He must do the due diligence in prior and must know all the relevant facts and information about the company or the property what they are getting into. Now, it is very important to analyze the risks which are associated with the business, and that is where the role of DD comes into a picture. Now, for example, if you are purchasing a car and you go into a market to buy the car, you will make sure that everything is working. The engine is working. The shape of the car is in proper place where you can buy it. It is new. all the engines, all the documents of that particular car are in place. Like when you're purchasing a car, you will make sure that everything that you need and everything you should get, you will get it. So now, why do you do that? Because you are investing so much of money to purchase a car. So you would want it to be in the condition that you want to purchase the car. Now, sometimes there are second-hand cars which are sold in the market. People know that it is a used car. There might be some defects. Now, when the buyer is going to buy the car, the buyer has to make sure that they are aware of all the possible defects that may come into picture while purchasing the cars. If the documents are in the place, if the car will give the proper mileage as described by the seller. So what happens here is, if the buyer finds some defect or faults which are not disclosed by the seller at that point of time, and they have agreed to, for example, 3 lakhs for a car, what can the buyer do? The buyer can say that these are the faults which I have found in the car, and you have failed to disclose it to me. Either you reduce the price of the car, then I can buy it, or I am walking away. So this negotiating bargaining power, which the buyer usually gets, is in the process of finding out what is the status quo of that particular car, what are the documents available, what are the faults, what are the defects, are these defects something which can be rectified? If they can be rectified, is the company in the position to handle the loss and still make a profit out of it? So that's where the DD comes into picture. Now, transactions that undergo a due diligence process offer higher chances of success. Why? Because due diligence contributes in making an informed decisions by enhancing the quality of information available to decision makers. Now, from a buyer's perspective, due diligence allows the buyer to feel more comfortable that his or her expectations regarding the transaction are correct. In mergers and acquisition, that is M&A, purchasing a business without doing due diligence substantially increases the risk of the purchaser. From a seller's perspective, due diligence is conducted to provide the purchaser with the trust. However, sometimes due diligence may also benefit the seller, as going through the rigorous financial examination, and also may, for example, reveal the fair market value, which were not disclosed in the initial process. Now, again, there are several reasons for due diligence, but to sum it up, it is to confirm and verify information that was brought up during the deal or the investment process, to identify the potential problems before placing your business opportunity on the market, to obtain information that would be useful in valuing the deal, to make sure that the deal or investment opportunities complies with the investment or the deal criteria. A lot of times it might happen that the business owners are reluctant to share the negative information about the company. It is fairly expected, but they want to put their best foot forward. And it also happens usually that the buyers, the sellers don't disclose the actual state of the company, because even they are aware if the company is not in the financial position or is not in the best possible shape, the sellers may tend to walk away. So this process usually helps the buyers as well as the sellers. Now, having said that, what is the purpose of preparing the due diligence? Now, the purpose of preparing for due diligence is to address the potential problems before placing your business on the market. Now, in order to attract a sophisticated buyer to your company, you must prepare for the due diligence process well before the sale process. Now, some of you might think, why would the buyer and also the seller be so intrigued in the due diligence process? I know this process sounds like, how is it so essential? But usually when you're investing huge chunk of amount and money into a property or a company, it is a very highly risk associated business deal. And usually the companies can go back and forth depending on the failing or completion of the transaction. A lot of companies which begin with the transaction with the LOI due diligence process also do not always end to closing. It is not necessary that once a letter of intent is signed and DD has been successfully completed, the closing, the post due diligence phase, that is a closing, will definitely happen. It really differs on a lot of factors which are associated in the mergers and acquisition or in the transaction. Now, it is definitely one of the vital and lengthy process in an M&A transaction, and usually the buyer conducts to confirm the accuracy of the seller's claims. Now, seller also wants to do the due diligence because it helps them and gives them a negotiating foot front in the way that the seller is aware of the liabilities which can be found out in the DD process. So what the seller does is they present and give the buyer a confidence that everything which has to be revealed has been revealed. We have put forth a transparency which is created between the buyer and seller, and usually the seller is also aware of the defects that might be found out when the due diligence process is taken out by the seller. Now, usually, a potential M&A deals or involves several types of due diligence. Now, they might be labor, financial, intellectual, real estate, environmental, legal. We won't be going in the depth of, due to the paucity of time, we won't be examining them in very much detail, but I will give you an overview of what these type of due diligence mean. Now, usually in labor DD, it means the analyzing the total number of employees, including the current positions, vacancies due for retirement, which are serving notice period, what are the salaries given, what is the bonus paid, which all are the existing employee contracts, which are the, with along with the non-disclosure, non-solicitation, non-competition agreements, which are signed between the company and the employees. Now, HR policies, what are the employee problems which have been, found in the past, for example, wrongful termination, harassment. So these are mostly the soft issues of merger, that is what we call. Now, in mergers, there are two types, that is the soft issues of merger and the hard issues of merger. In soft issues of merger, they mostly deal with the human capacity or something which does not influence the M&A transaction in large, but definitely plays a major role. For example, if I am a company situated in India, and if I want to buy a company or merge with a company which is situated in, for example, Germany, what happens is the employees of the two companies have to work together at some point of time. Now, there might be cultural differences. There might be differences on some other level, that how, like the functioning capacity of Indian type, the functioning capacity of the German. These are the factors which influence the soft issues of mergers. Usually, they do not lead to falling the deal apart, but sometimes if there are a lot of differences between the soft issues between the two companies which want to merge, it might happen that the deal might end up falling apart. So these labor usually refers to a little bit of soft issues of mergers, for example, language barrier, the timing, the people, are they comfortable enough to work with each other, the policy, or some organization have core values. Do the core values align? Now, when we talk about the financial, it basically checks whether the financials showcased in the confidentiality information memorandum, that is CIM, are accurate or not. Financial DD aims to provide an understanding of all the company's financials, including but not restricted to audited financial statements, statement of the last year, the AGM reports, the company's projection and the basis of such projections. And also it is very important to see the articles of association, because the articles of association are the constitution of a company basically, and it is very important to see the objectives and also the paid up share capital, the total investment. It basically involves the analysis of major customer accounts as well, the fixed and variable cost analysis of profit margins, examination of internal control procedures. Financial DD basically examines the company's order book and sales pipeline in order to create better or more accurate projections. Now, coming to the real estate DD, It is basically like type of an asset DD. Asset due diligence reports are typically include a detailed schedule of what are the fixed assets, what are the locations, if there are any physical verification should be done, all lease agreements for equipment, a schedule of sale and purchase for major capital equipment during the last 3 to 5 years, and real estate deeds, mortgages, title policies, and use permit. Basically, everything on the property side or physical assets, if any, all the reports related to that. Now, environmental due diligence is very important because if company by chance violates any major rule or local authorities can exercise their right to penalize the company up to and including shutting it down operationally. Hence, this makes environmental due diligence or audits for each property owned or leased by the company one of the types of due diligence. Now, there are few things that should be reviewed properly, that is list of environmental permits, licenses, validation of the same, copies of all correspondence and notices from the state or the local authority, verify that the company's disposal methods are in sync with the current regulations and guidelines. Coming next to is the tax DD. Tax DD in regard to tax liability includes a review of all the taxes the company is required to pay and ensure the proper calculation with no intention of underreporting of taxes. Now, additionally, verify the status of any tax-related case pending with the tax authorities, documentation of tax compliances and potential issues typically includes the verification and the review of the following. For example, copies of all the tax returns, including the income tax, GST, and sales tax for the past 3 to 5 years, information relating to any past or pending tax audits of the company, documentations related to net operating loss or any unused carry forwards of deductions or tax credit, any important out of the ordinary correspondence with the tax agency. The next we can analyze is the intellectual property DD. Almost every company has intellectual property assets that they can use to monetize their business. These intangible assets are something that differentiate the product and services from their competitors. Now, they may often comprise some of the company's most valuable assets. Now, a few of the items which can be looked in a due diligence review, including but not limited to, are the schedule of the patents and patent applications, schedule of copyrights, trademark, and brand names, pending patents clearing documents, any pending claims, case by or against the company in regard to violation of intellectual property. Now, when we talk about the next is legal DD, which is something very commonly heard term, and it forms a very part of the due diligence process, is examination and review of the following elements of the company, that is copy of memorandum and articles of association, what are the minutes of the board meetings for the last 3 to 5 years, minutes of all the meetings or actions of shareholders for the last 3 years, copy of share certificates which are issued by key management personnel, copies of all the agreements to which the company is a party. And it is also very essential to see if there is any restriction in the transfer of shares, because usually when the companies merge, the shares are transferred. So it is very important. It's a very key element to see if there is any restriction in the transfer of the shares in the copy of the memorandum, and which might lead to the influencing the decisions which might be taken ahead. Now, in DD, there are some compliances. For example, if there is a restriction on the share of transfer of shares, there might be some ways in which it can also be rectified. For example, it really depends on what the transaction is, but it can be rectified. So it is very important to rectify that first before going ahead. Now, any material contracts, including any joint venture or partnership agreements or limited liability company or operating agreements, are also essentials. Again, the copies of all loan agreements, bank financing agreements, and lines of credit to which the company is a party. Basically, when you are doing a due diligence, it is important and vital that you get all the information relating to the buyer. Make sure you have everything in documentation and also in proper way that it helps you to analyze the risk which is associated. If the risk is something which can be taken over by the new company, they usually proceed with it. They try to find out solutions to minimize the risk. If that is possible, again, it's doable. But if there are major red flags, usually the company understands at the end of the DD that if or not it is worth going ahead with the transaction. Now, there might be a simple cleanup. For example, non-compliances can be sorted. For example, some penalty has to be paid. Then the buyer can always say to the seller, these are the non-compliances. For example, there are 20 non-compliances, but 10 non-compliances are something which can be sorted by the buyer, by the seller. Then they can be sorted, and the rest 10 would be sorted by the buyer. Then that's when the buyer gets an negotiating edge over the seller, over the purchase price, or any of the conditions that might be suitable or favorable in the interest of the buyer. Now, usually what happens is there are DD reports done. Not all transactions go through, right? So if there is one transaction going on and a DD report was prepared of the same company, but it did not go through, or it fell apart. After again 2 months, there is again a deal which is going on between the companies. The basic question is, should old reports be relied? No, you should not rely on the old reports, even if it is even if it is done by the same firm or same company. What happens is, in the period of 1 to 2 months, or even for sometimes in the matter of 1 week, what happens is there might be some new complications or some compliances which are complied with. It is very important that the D process has been carried out all over again in order to ensure and protect the interests of the buyer as well as the seller. Now, it is very important for us to understand the transaction structure. In the previous deal, there might be some understanding in which the buyer and seller have agreed to a particular point, which depends on the understanding between both of them. But in the new deal, the transaction might be different. So it is very important before starting the due diligence to understand the transaction structure and get a very clear picture of the transaction. For example, get clarity on the expectations of the client. What does the client want? How can you protect the best interest of the client? So it really depends on what at that point of time what the client wants from you. So you have to make sure that you are catering to the needs of the client in the first place. For example, if the client wants to is fine with selling the company at the lower rate as agreed in the previous transaction, but does not want to undertake any reps or warranties. So it has to be structured or tailored in that way when you are going ahead with the process. Now, there are different sections, or there are different types of DDs. What we can say is, one is the red flag issue based. So basically, and the other one is full-fledged information report. So it really depends what the client wants. Now, red flag issues-based report is something which highlights only the red flags or highlights very specific issues which the client wants to find out. He's not interested into the complete due diligence and what has happened in the past. The client will tell you key, for example, they want to see what are the litigations in place. So this gives you very specific and a very tailored DD report that highlights a specific issue and findings which are material to that particular point which he has asked for. Now, the other is full information fledged report. Now, full-fledged information report is all the information regarding, like the assets, the finance, the litigations have been summarized. So we just took an overview of two types of reports. One is the red flags, that is the issue-based report, and the full-fledged information report. So it is very vital that we ask what that client wants. And it is very essential that we lay down the scope and exclusions. For example, exclusions in the sense that sometimes you need to carry out physical searches, and sometimes your information is available on internet as well. So we have to notify that where has that information be taken from. It is very essential to mention that sometimes what happens is the client gives you the papers, so that is fine. You can say that as per the document dated so and so, as per provided by the client. But sometimes there are searches which are done physically or which are done online, so it is very important to mention that this piece of information, where did you get it from. So while reading the DD report, no one should be in a confusion that, oh, where did this information come from. So it is a very factual basis, and it has to have a reference to some document, which document, what was it dated, where did you find it. So it's very essential that you can track the basis of the past documents on which the DD report is conducted. Now, what happens sometimes is you have completed the DD, everything is done, and you are submitting the DD report. At the last minute, the target company gives you some other document. Now, you know that you have to submit it today, and it's not possible. You don't have so much of time to go back and sit and review, because it takes time reviewing the facts and information of the document. So what do you do on the DD report? You mention today's date as the cutoff date, that this review of information, whatever the report is mentioned, is limited to this particular date, and the new document should be put it at the end. So these, and usually what happens, at the last minute, you never know, right? Like any document can come into picture. So in order to not to delay the process, it's very important to understand the concept of the cutoff date. And there is also a look back date. For example, sometimes the clients are not interested. A company is into formation since years at times. So, sometimes the client is not interested into the details of the companies over a certain period of time. So what happens is, a specific period is mentioned, that information from this date onwards is presented in the DD report, and there are few years which are excluded in the previous ones. So, but some information, that is some material contracts, which are still in existence, shareholders agreement or the confidentiality agreement or the non-disclosure agreement with third party, these agreements are very material information and they cannot be excused. But the information which is not that vital and not material, it can be excused from the look back period. Now, how long is the due diligence process? Due diligence can take up any period of time, as long as the buyer and the seller agree. The typical due diligence for most of the small and mid-sized business is 30 to 60 days. Now, a length of the due diligence can be based on the following. A length of the due diligence can be based on the following. That is the availability of the information. If the seller responds promptly to the buyer's document request, the due diligence period can be shorter. Turnaround time. This depends on how fast the buyer reviews the information. If the seller provides information in a concise and organized and clear manner, you will definitely speed up the due diligence process, but it is definitely not necessary always that the papers will be organized. To a certain extent, yes, but what happens is there's a huge chunk load of documents which are presented. So it takes the time to categorize and to make sure that everything is in particular way. And communication. If the seller is more available to the buyer, this may also shorten the due diligence process. But again, it really depends from person to person, from buyer to seller, what are the expectations of the transaction. So there is no definite period, but in practicality, it does take over a longer period of time, but they always set forth a time limit in order to ensure that the transaction is moving ahead in a secured, and it secures both the interests of the party. Now, who carries out the due diligence? Sometimes seller might initiate, which is called the vendor's due diligence. Now, seller also can initiate because, they want, as I said earlier, the seller wants to be aware of the material facts and faults in the company. And when they're aware of all the liabilities, they can also put forth showing what are the assets in the company. So in order to balance it out, usually the seller also initiates the due diligence process. Now, DD is of course important from both the ends, being transparent, clear understanding of what status quo is, highlighting the assets and liabilities. Um, so yeah, it really depends, but usually seller or the buyer or both the companies at times do the process. Now, due diligence phase of M&A transaction. Since this lecture involves around the basics of due diligence in M&A process, I am not going into technical details of the M&A transaction in general. But again, there are different phases. Phase 1, phase 2, phase 3 is our due diligence process, which includes plan M&A due diligence, organized due diligence teams, define due diligence approach, methods and protocols, conduct M&A due diligence, compile and analyze due diligence finding, the phase 4 and the phase 5. Now, when we talk about the summary of the due diligence, now, to give you a very simple idea about where due diligence fits in and what is the structure in the M&A process, it is the letter of intent. The parties negotiate and accept the letter of intent. Then is the due diligence process. The due diligence period begins immediately after the letter of intent is accepted by the parties. Then we have different types of agreement, that is the purchase agreement. The parties normally begin preparing a draft of the purchase of the agreement during the due diligence phase only. Now, because it takes weeks, if not months, to negotiate and finalize, because it is a huge document and they are going to find out new findings every now and then, and putting that document back and forth between the parties, it takes time because everyone is going to take their own time to review the document, because ultimately that is a vital document which will be signed by both the parties and it will close the deal. So they usually started during the due diligence to ensure that there is an efficient closing within the minimal days. Now, closing of due diligence at any point during the due diligence or upon its expiration, the buyer may decide, that they are satisfied with the investigation of the business and want to proceed ahead with the transaction. Now, the buyer may also do this because the buyer and the seller have resolved whatever contingencies, or even if there are pending contingency, the buyer may feel confident enough to enter into a definitive agreement to record the terms of the transaction or understanding between the parties. Now, when this happens, what happens is the buyer and seller will sign an agreement stating that the due diligence process has been concluded. This signifies the completion of DD and the parties' decision to end the investigation and proceed to a very definitive agreement. Now, there are some contingencies that survive during the due diligence. As I mentioned earlier, there are reps and warranties which form an integral part of the transaction as well, because not always all the compliances are satisfied. So buyer or the seller may undertake to, at the cost and expenses of the seller. The buyer may say that I will finalize this compliance post signing of the agreement or pre-signing of the agreement. So it really depends understanding the structure of the transaction, but there are different contingencies that survive due diligence, such as financing, franchisor approval, lease agreements, or license transfers. As we had an overview before, there are agreements involved. So usually the agreements have a third party clause that if the seller is getting into a contract with some other new party, they have to take a consent, a written consent of the parties they have signed the agreement with. So it is very necessary that when going through the agreement, also you just don't see what the agreement is. You see if there are any restriction. As we saw in the memorandum of understanding, if there are restriction in transfer of shares in the real estate or asset DD, it is very important to analyze if there are restriction of transfer in the property also when you go into mergers or acquisitions. So these are the contingency, usually they survive. Usually these are conditions subsequent, because usually the people do agree, they do not create any huge impact, because the buyer is buying the property and he usually signs an undertaking saying that he will maintain the property the way it was earlier. So this is just very specific to the real estate DD. Now there are different conditions in the provision. So sometimes the seller is not aware of something. So what happens is the seller gives the representation that to the best of my knowledge, to the best of the company's knowledge, this thing is non-existent, or this is what is available information. You might not always have a documentation on everything. So the seller gives the reps and the warranties at times on the seller's end also, that they will comply or they will pay the penalty at the cost of the buyer's expense. So reps and warranties is again an essential term, and these are the contingencies that survive the due diligence. Now, then we come to the closing. Once the contingencies are met, the closing may occur. Now, in most cases, the purchase agreement is signed at the closing. However, it might be sometimes signed prior to the closing also. Now, closing and signing of the agreement is two different phases altogether again. Just because it is signed doesn't mean that the transaction is closed. There are some here and there formalities which are usually required, which might be completed later on. So, having said that, this is what the process of the due diligence in M&A is. I know due diligence is something very vital for sure, but on an external end, it doesn't seem like a huge big deal. But when you are with the parties, when you are with the negotiation phase, you understand the importance of the due diligence. Because if we go into a market to even, for example, buy a piece of cloth, we make sure that the cloth is proper because we're paying the price for it. So imagine when the companies are buying and selling, and the mergers and acquisitions are happening at such huge level. There is huge amount of money that is involved, huge amount of investments that are involved. So it is very essential to analyze from the smallest piece of information to the biggest one, in order to safeguard the interests of both the buyers and the sellers. And after the post closing, the company can function very properly. So I think that's it. I hope this session has given you at least an overview of what is the due diligence process, why is it necessary, and how it entails to be one of the most important components in the M&A process.
Thank you, ma'am. Now we will move forward to the Q&A session. So the first question is from Mr. Nishan Jain. That is, what is the basic difference between equity value and enterprise value of a company? And in the case of an acquisition, what we should consider, the equity value or the enterprise value?
When we talk about the equity value and the enterprise value, the equity value is mostly in the liquidated form. So in the case of acquisition, it really depends on what the companies are signing up for. For example, when we do a lot of transactions, now, for example, in mergers only, there is no one specific form of purchase agreement. There might be a share purchase agreement. There are a lot of different mechanisms, that is lockbox mechanism, which is used. Sometimes it's just asset purchase agreement. So I think it is vital to understand what are the needs of the parties in the first place. And depending on that, we can move ahead to understand what is taken into consideration, the equity or the enterprise value of the company.
Thank you, ma'am. Ma'am, next question is from Yasraj Base. That is, are there any specific provisions in Sales of Goods Act or Companies Act 2013 that penalizes the wrongdoer on ignorance of due diligence?
So when we refer to the law, I think, as I said, there is a principle of caveat emptor, which plays a very huge role in any selling or buying of, be it a property or a company. So it is very vital that buyer should make an effort to understand what they are buying at the end of the day. So ignorance of law is again a no excuse. And once the buyer buys in a hassle and gets into some legal trouble, the buyer cannot blame the seller at the end of the day, saying that you did not disclose the information. It is very vital to understand what the buyer is buying, and buyer is being ignorant with not seeing the due diligence at the end of the day. So I think it will fall on the buyer because the buyer is not being aware of what they are getting into.
Ma'am, next question is from Jay Sanwalia. That is due diligence enforced as a form of contract?
Due diligence is not enforced very specifically as a form of contract, but usually both the buyers and the sellers prefer going through the due diligence process in order to understand if and if they should proceed ahead with the transaction. Now, put it in a simple way, DD, as I said, very simple example. When you're going in a market, even if you're buying, for example, 10 rupees chocolate, if the wrapper is unwrapped or if it is not at the best possible position, you are not going to buy it. It is not just a matter of money, but if you're paying for something, you would want it to be in the best possible condition. So basically, it's just that buying and selling of companies, you would want it to be in the best of health, best of position financially and physically also, and make sure that whatever you're buying is the best product available in the market for the price that you're paying.
Ma'am, next question is from Ms. Vishweshwari. That is, which is the best type of due diligence that can be used?
There is no specifically best type of due diligence. As I mentioned earlier, it really depends upon what is the structure of the transaction and also what does the client want, what are the needs of the client. Sometimes the client just want to sell off the company, even if they get for the lesser price. So it really depends upon the seller and the buyer, what type of due diligence they want to enter in. As I mentioned earlier, there is issue-based DD report that just highlights whatever the red flags are with respect to a specific issue. So it really depends on the transaction.
Ma'am, next question is again from Yashraj. That is, what reforms are necessitated by the government in the present context to overcome the lacunas in due diligence with ensuring consumer welfare at large?
Again, it traces back to the principle of caveat emptor, as I've been mentioning. It really stresses out on that because, not just the mergers and acquisition. For example, in property also, when I'm trying to buy thing, I should be aware of the position that particular property or commodity is. So when we talk about the government, obviously there are a lot of case laws in which even after due diligence some contingencies are not disclosed, and there have been the matters which have gone into the court. So depending on the case to case, sometimes some information is not disclosed, but it is not that material. For example, it is compliance related. There is a penalty which the buyer and the seller had no idea even after conducting the due diligence. So it might be rectified, but it is something, if it is something so material that it leads to falling apart of the deal, then it comes into the question. When you go to the court, then the evidences are given into question, and depending on the case to case, or depending on the material impact that due diligence which was undisclosed will have that on the deal, it depends on that.
Thank you, ma'am. Ma'am, next question is from Kshitij Rajpurohit. That is, if the seller is able to hide an important fact about its firm during DD process and after the merger it is revealed, what are the legal consequences and remedies for the other party?
So if the seller has hidden the details, so usually what happens is, it's very unlikely that it happens because usually the buyer what happens in a practical sense, the seller also conducts due diligence and buyer also conducts due diligence. At times it might be possible that some information is left with the seller which they have not disclosed, and the buyer has also not been able to find out. Again, the impact of that material non-disclosure, depending on the transaction, will be taken into account when they go to the court. If it is so material that it leads for the deal to be falling apart, then some compensation can be claimed against the company. But sometimes what happens is, we need to understand one thing. Mergers and acquisitions of the companies, it's a very huge deal. It's a very huge investment. As a layman, when we are on the outside, we don't realize the consequences, and we don't realize how much amount of money and assets and liabilities are included. As on the outside, it seems on a very simple level, but when you are in it, there are a lot of things that are going on. So even if sometimes the material information is not disclosed, and what happens is the seller will tell the buyer that, listen, let's try and sort it out between both of them. They don't immediately go to the court because there's huge amount of investment involved. So you can't directly go to the court. They want to settle down together. Sometimes the buyer, if the buyers are doing the due diligence very properly and they are able to catch hold the loopholes, they take reps and warranties from the buyer. So if the reps and warranties are not taken, and if it is not disclosed, when it goes to the court, usually a settlement also comes into picture.
Thank you, ma'am. Ma'am, next question is from Manjeet Singh. That is, ma'am, can soft issues of a merger can affect or end the deal of companies?
Yes, actually, soft issues can end the deal of the companies. I don't know how many people know the Mercedes, that is the Benzler case. It was based solely on the soft issues of merger. I think it is traced back to some 90s, and that is a German company, if you know Mercedes Benzler's case. So it's a German company. So it was one of the highly known deals in mergers and acquisitions history. What happened there was the hard issues were fine, but the people, when the company was bought, couldn't function together. There were so many differences, cultural differences, and they were just not being cooperative, because sometimes when you hire, a company works on a very specific system, hiring, how they level up. The other company has a different procedure to level them up. So what happened in that case was, when these companies merged together, they couldn't even come to a consensus about how to hire people, what are the benefits given. There were so many cultural differences that they would barely be able to communicate. So one thing that happened extraordinary in this case was, people of the company were given training, how to talk with the people, how to deal with them, how to make sure that other people are comfortable working with them, but they just couldn't. Like, these were the issues. These sound very minimum on the on the outside, but when it happens in person, you have to understand that the company can't function. Only the company will fall apart because the employees themselves are not in conjunction of the functioning of the company. So in that case, even though the merger happened, after a few couple of years, the merger fell apart because of the soft issues of merger.
Thank you, ma'am. Now the last question is from me only. That is, if a private company merged with a public company, what will be the status of the new company? That is, new company will be a private or a public?
When a private company is merging with a public company.
Yes, ma'am.
So what do you have any shareholding in mind? Because on the practical sense, we understand, like, if A company merges with a B company, it has to be a private or it has to be a public company. But usually the shareholding pattern of that particular company, and also the transaction, it really depends on that whatever the company, which is the forming company, will have that influence. If there is a lot of public shares, it deems to be a public company. And if there are a lot of private shares, the majority of the shares will have that effect. And if and at all, the merger can happen.
Now the next question. Next question is from Yashraj. That is conditional merger allowed by NCLT when there are huge liabilities and criminal charges pending against the company? Does it amount to violation of due diligence?
If the seller and the buyer have that transparency between them, and both the companies are aware of what they are getting into, it doesn't involve on that side. Basically, the buyer is very well aware of what is going on. So with the full conscience that they are entering into, there are some reps and warranties that are signed, and also on the seller's end also usually they are signed. So it doesn't amount to it. But again, depending on the facts and circumstances of the case. So whatever I'm saying here is very dependent on the transaction structure in any given case. This is one difference you understand when you actually start practicing law. And when you read, it is very clear, A plus B is equal to C. But when you actually start practicing law, you understand that amount of A, the amount of B influences the C. There is no correct left and right answer to this. It really depends upon what are the needs of the parties, what does the client want, what is the end solution to it, are there any material factors that influence the deal to such an extent that it falls apart. So even now also, you must have not heard, there are not a lot of merger deals that fall apart due to soft issues of mergers. Not many people even focus on soft issues of mergers in the first place. But when you want to do a due diligence, it's very essential that you take into a factor which might even cause 1% liability and which might lead to falling apart of the deal. So it's a very huge difference when you start practicing law and entailing into a like due diligence transaction in person than what you're reading in the books.
Thank you, ma'am. Ma'am, now one last question from Mr. Yash Pathak. That is, in case if law officer of company A discloses private issue to company B for making sure the merger of both companies, can company A sue law officer to break client attorney privilege?
Can you please repeat it again?
Yes, ma'am. If in case a law officer of company A discloses private issue of the company A to company B for making sure that merger works properly, then can the company A sue the law officer to break the client attorney privilege?
Again, now, when you talk about this, we need to understand what the situation is. Under law, if the seller is asking for a specific information, like for example, if the seller is asking to the law officer, are there any litigation pending? Then the law officer, ideally, because in that capacity, has to disclose irrespective of, whether the company A wants them to disclose or not. Because if they do not disclose, what is the practical solution? A says there are no legal pending litigations. So what will I as a seller do? I will ask them to write a representation that to the best of the knowledge of so and so person, this person has confirmed that there are no legal pending litigations as of like today's date. Now, the seller won't sign this because the seller knows that there are pending litigations. And if they sign it, that means that they are breached the confidential information. So this can have litigational charges, or it can end up in the court. So if the seller is very specifically asking them to disclose and they are lying about it, the practical solution which I will take as a seller is to take a rep. If they breach the rep, then there are, I'm sure in the clauses we do write some compensation and damages, that if any warranties or representations are false, this damage is payable to the seller.
Thank you, ma'am, for answering all the questions. Now I would like to call upon Garima Shukla for vote of thanks.
Thank you, Vineet. Gratitude is not only the greatest of virtues, but the parent of all others. Thank you, ma'am. So we have reached to the end of this knowledgeable session. I, Garima Shukla, take the opportunity to deliver a hearty vote of thanks on behalf of Department of Law, Prestige Institute of Management and Research, Indore. Would like to express my sincere gratitude to Ms. Utkarsha Nikam ma'am for sparing her valuable time and her forethought, giving us precious knowledge in abundance. I would also thank Assistant Professor Kamlesh Jain sir for organizing today's EML and for his vision and guidance at every step. I also thank Assistant Professor Nakul Singh Chauhan sir for his support throughout the session, and Assistant Professor Navratri Dunde ma'am for her presence throughout the session. Sincere thanks to all the student coordinators of EML committee, Mr. Priyanshi Jain, Mr. Nishan Jain, Mr. Kshitij Rajpurohit, and all other committee members for making this EML a true success. Most important thanks to all dear students for being patient and gaining all the knowledge. Thank you so much, ma'am.